Hi, good afternoon. Today is October 22nd, 2025, and it is 4:45 p.m. U.S. Central Time. My name is Rinaldo J. Aguiar Marcano, and I'm recording this video from my home located at the 26714 Valleyside Drive, Katy, Texas, 77494. Give me just a second. Let me adjust here a couple of things. I can do this better. Okay. Sorry about that. So today I have just a couple of updates on the legal front, but also I have something that I think seems to me like it could be important, and so I'll talk about that first, and then I'll talk about the legal updates on the legal front, right? So this observation, right, that I think could be important, comes from the pipeline, and I posted on YouTube some of these already, but I'm gonna go a little bit deeper and recount how this happened, right, in the first place, because sometimes the devil is in the details, and I think this is a good example, right, of that thing that I sometimes say to people. I say, it's kind of a computer science inside, right? Like I always say to people that you should always prefer memory over CPU, right? You should always prefer RAM over CPU. And but, I don't want to derail the conversation with technical stuff, but I think that's pretty accurate, right? So anyhow, what happened was, I've been running the legal vaccine, and there is a judge here in Texas called what is his name? A. Wayne Bailey is his name, and he's a judge, an active judge in Bryan, Texas. And this is a person that I actually interacted with a couple of years ago when I was fencing off Max Tarasiouks, the FSB agent. I think he's part of the Kilpatrick team, and basically Max was doing something very similar to what Phil Denning was doing, when in different contexts, right? So what Phil Denning was doing was, as president of the HOA of Lake Point State, he was sending me emails, inventing stuff, like making up things that never happened, to put things in writing that then could be used in court, right? Like, for example, in one instance, he said that I forcibly entered the security guard's house at Lake Point State, which is not true. I never entered the. Or in another instance, he wrote that I attacked the guard, like things like that. Like he would make up stuff, but just to put them in writing, right? And the objective of that is to then, in a future date, they would print those emails and produce exhibits with, a Morgan Hybner or a Troy Pickett or similar, right? To weaponize those things in the future. It's kind of creating evidence, not to use it immediately, but to have it there, right? So when they need it, they have it. So Max, who was supposedly, right, an external sales agency working for me, for my company, right? So the idea was, and was what he pitched to me and what I agreed to, right, that he would market my technology and I would give him a percentage of what he sold, right? And he could manage his sales operation. I would have no saying in how he did things. As long as he sold something, I would give him a percentage, right? And this is an arrangement that is called a sales agency, right? An external sales agency. But what Max was doing was fabricating evidence to then claim to manufacture an intellectual property claim, right? Like in his emails, he would insert things like, like he would be talking about something in the email, right? But he would casually say something that would include the word partnership, right? Or he would insert a phrase that would say something like, this thing we're building, right? Like things that could be read by a judge as, these guys built this together, right? It wasn't Reynaldo's technology. It was something that Max actually participated in building, right? Which is not true, but he would insert those phrases like in places that were ambiguous, right? Like it wasn't clear what he was talking about, but he was doing this consistently, and I saw what he was doing, right? So anyhow, during that process, well, before I get into that, right? So what happened was the pipeline flagged Judge Bailey, right, from Bryan, Texas, years ago, right? As I, in the first month after I captured the GeoIndex, he was flagged, right? But what was recent is that he got co-clustered with Troy Pickett, the mysterious attorney that appears in every case but never says one word in any case, right? He's like a placeholder, right? Like he's there just like waiting to be activated, basically, right? So Troy Pickett got co-clustered with Judge Bailey from Bryan, Texas, for many reasons, right? There's a lot of data that I have, but I'm not going to get into the details of the co-clustering, but because it's beyond the scope of this session, right? And that caused, because of, and also I can't go into the details of the technology for obvious reasons, but because of the, how do I phrase this? Because of the recent events in these local courts, right? The fraud that Morgan Hybner committed against the two courts, and that Troy Pickett has been inserted as official attorney in both cases, right? That caused the score of Troy Pickett to be super increased, so high, right, in the pipeline. And because of that, the score of Bailey jumped up a certain threshold that I have. And now Bailey seems to be, when I say seems, I mean from the perspective of the pipeline, right? Like if I read the debug output, it seems like Bailey is a key player in all this, right? And that triggered in me something that, curiosity, right? I have this natural curiosity to understand. I don't know. I'm driven to try to understand things. I don't know why. I've been that way since I was a child. And that made me question myself about why would they insert Bailey in 2022 or 2023, right? Why? I mean, Bailey is an active judge in the Texas, and not any, I think he's an administrative judge. So he's a judge for matters related to the government, right? He's not a family judge, a family cases judge, like Judge Telfair, right? Bailey is higher caliber than Telfair in terms of the powers he has, right? So obviously, my curious mind has to ask myself, what was the need to insert Bailey into the equation? I mean, it feels like killing a mosquito with a bazooka. You know what I mean? Like at that point in the timeline of things, I didn't have the GeoIndex. I wasn't even aware that the SEBIN, the Venezuelan intelligence, was running Katie, right? I wasn't even aware of. I was naive in every aspect you can think of, right? I wasn't even aware that Francisco Castillo and Marcos Castillo and Daniel Parra were agents of the SEBIN. Like I didn't know any of that, right? Well, to the point, that was around the time I was buying dummy cameras in Amazon for $5, thinking that that would deter Michael Pretty, to give you an idea of the level of naiveness that I was in at that time, right? So why deploy a judge to gather intelligence, right? It doesn't make sense. So that, made me remember, right, what was happening at the time. And that's why that's what I want to record in this session, right? Because I think that's what escalated all that, right? All this, right? That's what led to this point at the end. So I'm gonna tell you from memory, and this is what I say, that it's more important to have memory than CPU. I want to tell you from memory what I recall. Okay. So this is what happened. At the time, I was developing the system that I call the KOL vaccine, which eventually evolved into the pipeline, right? But at the time, it was a system that I used to fight the online attacks by Briscoe and WebMD against my websites on Google search. They were doing this CTR attack to demote my websites, right? So I developed this technology, which they stole. They took me to New York on the pretext of giving a pitch to President Leonel Fernandez of the Dominican Republic, and I fell for that, and I went to give the pitch to him, and I gave the pitch to him. And they locked me out of the hotel room, and they got access to my computer, right? So that gives an idea of how important the KOL vaccine was to them, right? That they went to the extent to engage a former president of the Dominican Republic to steal the technology, right? I mean, I'm saying that President Fernandez knew what they were doing, but he gave me the meeting to pitch to him, right? And it's not easy to get a meeting with the president, right, or with a former president. So that gives an idea of the level of strings that they had to pull to get me to New York, right? So they could lock me out of the room and get the computer. But anyhow, so at the time, right, I was developing that technology. And as I was developing, I was doing more or less the same thing that I'm doing right now with the courts, right? But with Google, I was debugging how is that they trick them, right? How is that they trick Google into promoting internet brands websites over anything else, right? And of course, I was debugging all sorts of queries, right? And as I was doing that, I saw that the same technology they were using to attack my website, they were using it. And I have to say something, right, before I say this. I never mentioned this because I don't want my statements to become a political thing, right? Like this is not a political. I'm not. This has no political angle. I haven't said this in years, right? And I've known this for years, and I haven't said it. But when I was debugging the queries that they were using to attack my websites, I saw that they were attacking the names of prominent political figures in the US and in other countries. Of course, and now having the UA index, I understand that that's a complementary technology that works with Smartmatic, right? So on one side, they commit fraud on the elections, and then the other side, they manipulate the public opinion, right? And then the thing works, right? So I saw in 2022, 2023 that they were attacking the names and demoting them in Google search. They were demoting prominent political figures in the US and in other countries. So when I see that Michael Pretty is an agent of the FSB, right, my first reaction was to seek legal advice, right? And of course, because they control Google like a puppet, Google search, when I searched for a lawyer, they presented me the top result was Rhough. What is his name? The last name is Rhough from Legal Labs. I have to look up the name. I can't recall. I can't recall the first name, but the last name is Rhough. Okay. I think it's Roughh. And the company was supposedly called Legal Labs, but I imagine it's one of those fake companies that they set up overnight, right, to do this process. And he was an Asian gentleman. Like he had very strongly marked Asian features in his face. I think he was probably Asian descent, Chinese descent specifically. And but he spoke perfect English. Like he wasn't an immigrant, obviously. Like he went to law school in California, and supposedly, well, that's what he told me, anyways. Gene is the first name. Gene Rhough. So anyhow, that's the first result, right, that I see on Google. The query that I did was something like, legal consulting for startups or something like that, right? And he came on top. So I meet with him, right? And I gave him a demo, naive me, right? I gave him a demo of my KOL technology and how I was seeing, but it wasn't a very deep demo, right? It was like maybe like a half an hour. And I gave him some examples of how these people were manipulating Google at a massive scale, right? And I told him the implications of that, right? In economy, in politics. And as we are getting to the conversation, right? At the end of the conversation, he tells me that his former boss, and I don't know if this is true or not, like I have no way to verify this, but this is what he told me. He told me that his former boss held an important position at the DOJ, at the Department of Justice, and that he was going to consult with him and he promised me that he would try to get me a referral to the DOJ so I could present this information to them, right? I'm talking about 3 years ago, right? As we're closing the meeting, right, he asked me the question, but what else do you think they're doing with this, right? And I told him, it's not that I think, I see and I have proof that they're attacking the positions in Google of prominent political players in the political landscape in the US and in other countries as well, right? In Panama, in Venezuela, in Russia. And he tells me, he says, send me what you have, right? This is what he told me. He asked me to. Send me what you have, and I'll, forward this to my former boss. So, looking at the whole situation, right, and the gravity of what I was seeing, because I understood what I was seeing, right? I was naive about all this, but the data is unescapable, right? If I'm seeing the data and the volume of impressions that they're putting into Google every day, right, and the queries they're targeting, I understand the implications. I mean, the global political and economic implications of what they're doing, right? So to be honest, I wasn't scared to send any information because I didn't know this person, right? I just met him for an hour, right? So I sent him an email. I sent something, but I didn't send what I knew, right? I sent something ambiguous and generic, right? Of course, he never replied. He never gave me any referral to anything, and the thing died. It was just an operation to extract information to know what I knew, right? And importantly, he didn't help me with the problem I had with Max, which is what I was looking for help with, right? Because at the same time that they were attacking my queries, Max was inserting all this language in the emails that I could see that would lead to an intellectual property lawsuit, right? I could see ahead what was coming, and I wanted to deter Max, right? That's why I hired Rhough to deter Max. So anyhow, he didn't help me, right? In fact, I think I paid him, he asked me for like $1,000 retainer. And then we had that meeting and he never gave me the money back, right? Like he basically stole the rest of the money. But I had other things to occupy my mind with. I wasn't going to start fighting with Rhough for, $300, $600. I don't know how much he owes me. So I didn't even ask for the money. But then I kept looking for a lawyer because I still had the problem of Max, right? Writing these emails and trying to create grounds for intellectual property lawsuit. And that's exactly the moment when Wayne Bailey, this judge from Tyler, Texas, appeared in my life, right? And I asked him if he would do me the favor of, replying to Max emails as if he was my inside counsel. And he said, yes. He told me he was a former judge. I didn't know he was an active judge because if I had known that, I would have not hired him because I see obvious conflicts of interest. I mean, I don't want to get into any trouble with, the judiciary system of the US, hiring a judge to do something for me. So, but he lied to me and he told me that he was a former judge. So I hired him and I gave him access to my domain, keyopinionleaders.com, and I gave him access to an email address. Then he forwarded to his own email address. And this is crucial because to forward, this is technical, but it's important because it's proof that this happened, right? So I used, for key opinion leaders, Google Suites, Google Workspace, I think is the new name of the product, which basically gives you access to kind of an instance of Gmail internally, right, for your company under your domain name. And we set it up, and with Gene as well, in a way that the emails will be forwarded to their emails, like to Gene when I was, supposedly working with Gene, and to Judge Bailey when I was supposedly working with him. And this is crucial because for that email forwarding to work, they have to receive a confirmation from Gmail saying, hey, Rinaldo is trying to forward this email to your email. Do you accept? And they have to click on that link, otherwise the email forward doesn't work. I'm saying this because this proves that they knowingly accepted that email forward, right? They took active steps to make this setup happen. Right? They can't claim that they didn't know what they were doing. So Judge Bailey clicked on that link, and he accepted the email forwarding. And he replied to Max. He drafted a letter. He replied to Max, and Max went away. Max didn't bother me anymore. So apparently it worked, right, what he did. But now I understand, right, why they deployed a judge, and not any judge, right? A judge that deals with government institutions. Because the allegations I was making and the data I was seeing on the queries they were attacking, and I'm talking about Briscoe and WebMD and Liana Technologies, and had tremendous global implications, right? So they had to respond hard, right? And what better way to respond? I mean, what's harder than engaging a judge, right? So that's the reason why they engage Bailey. Is because I make claims to one of their attorneys that I knew that they were manipulating the online queries, basically targeting political players, people that participate in elections for public office in the US and in other countries, right? Which is in itself ironic, right? Because if you think about it, right, what I had back then was something like the pipeline that I have today, but it operated on using as input whatever data is publicly available from Google, right? From Google search, like Google Trends and things like that. And because they were trying to bury that, right, that didn't become public, they escalated their operations to the point where I could see that they were using an automated system like Uber to spy on people. And that led to the capture of the GeoIndex, which has all the tracking points, all the houses, all the antennas, and the crypto payments, right? So it's really ironic, right? It's really, I don't know how you say that in English, but it's like, it's a demise of their own making, right? So yeah, this exercise, right, of digging back in memory of how this person came into my life. I'm talking about Judge Bailey. It's a confirmation. I mean, what I'm remembering, right? It's a confirmation that that what the pipeline is saying is exactly that way. Like, he's a key piece of this, right? Because if he wasn't a key piece on all this, they wouldn't have engaged him, right? I mean, I was making allegations that they were manipulating the elections, right? Of all the elections in the entire planet, right? They had to hit hard, right? And that's why they engaged that specific judge. And fast forward three years, and the pipeline is saying, this is a key person, and by extension, Troy Pickett has to be a very high level player, right? Because I mean, the pipeline could cluster them together, and how do I say this? The stakes are even higher now, right? Because, well, I mean, now that I captured the GeoIndex, it proves that everything I was saying to Gene Rhough 3 years ago was exactly like that and worse. And now I have hard evidence, the GeoIndex, and the fraud of Morgan Hybner, right? Who committed this fraud with the sole purpose that the Appellate Court would not see the transcript of one of my demos, the one I gave on June 9th, in which people are mentioned, like Robert Mueller, Phil Denning, the Roberts Markel law firm, right? Eckhart, Damon Sachs, right? So just to hide that transcript, they committed fraud upon 2 different courts in a single document, right? So, and the person that is brought in to try to contain that damage is Pickett, right? I guess what I'm trying to say, right? If, you know, if they made that decision 3 years ago, right? When I made those claims, they hit hard, right? They brought a top player, the judge, right? And now that I have hard evidence, right? The geo-index and the evidence of fraud, they have to hit hard as well. They're not going to bring, you know, a subpar player. They're going to bring the best they have, right? I mean, the most ruthless they have, right? And that is Pickett, right? So, I don't know. Speaking of that, I'm going to now transition to the legal updates, right, here in Katy. So, they are in disarray, right? They're panicking, so Morgan Hybner is trying to get off the case. But, and you know, like, it's sad that I have to say here that I know this. I mean, at this point, they should know that I know this, right? Like, it's silly, right? Trying to trick me in this way. I mean, it's obvious that I know this, right? So she sent me, well, somebody from her law firm, right? Send me, so the sequence of events. I filed, you know, evidence of the fraud with the federal court. I mean, the fraud against these other 2 courts, the state courts. I filed that evidence with the federal court on Friday. The next business day, so yesterday, being Monday, Morgan, somebody from her firm, sent me a document titled Order Motion Agreed for Withdrawal of Counsel, right? Something like that. Something that said order, it said motion, and it also said agreed. I read the thing, and it's basically Morgan Hybner saying that she's going to leave the case. And importantly, I think she has the duty to mention what is pending, right, on the case. But she omits that there's 4 motions for sanction against her. In that document, she doesn't say that, right? It's a material omission. She is hiding information to the court of something that is relevant. I mean, she cannot leave if there's claims of misconduct and motions for sanctions, right? But anyhow, she sent me that. I do not respond because, of course, I'm not going to agree to that, right? And I'm not going to engage with them into why I don't agree. I didn't sign it, right? So today, they filed that document with the court, and they put in the title, agreed, in past, as if I had agreed, right? Implying that I had agreed. And then they went further. They filed a proposed order saying that it was okay for Morgan Hybner to be off the case. So they were trying to pull the exact same trick again in less than a week. Well, in 11 days, right? So 11 days after the first fraud by changing the title of the document for a title that has nothing to do with the document, they did it again in the 387th court. So this time, filing this supposed agreement that never happened. I never agreed to anything, and I will never agree to that. Never. I want her to stay in the case for as long as the case lasts, right? And I will defend that to the end, right? So they did it again. They again filed a deceptive title document to trick the court. The idea here is that if they're saying, right, that this is a motion that is already agreed by the 2 parties, the judge may not even need to read it, right? He could just sign, right? But it's also fraud, right? Because first of all, I didn't agree. And second of all, I filed a second verified motion to recuse the judge on October 16th, and that triggers an automatic stay of all matters. The judge can't sign anything, not even if the 2 parties agree. Even if I had agreed, the judge should not sign that because the matters are at stake. The motion to recuse needs to be resolved first, right? And then, if there is a recusal, then a new judge has to come in and get up to speed, right? And then the matter should be decided, I imagine, in order of importance, priority, and time they went into the docket. I have more than 12 motions that haven't been ruled on, right? The only motions that have been ruled on are Morgan Hybner's motions. My motions are never read or ruled on unless they're motions to recuse. Those are the only two exceptions. And that's because those are mandatory. They have to review them, right? And maybe this is a good point to say this. I have an idea, right? I don't mean to overstep or tell people what to do, but like from being on the receiving end of this, right? It seems to me, and I mentioned this before, that the weapon is making law inaccessible to common people, right? To people like me that are not lawyers, right? So you have necessarily to go through a lawyer to get access to justice, right? And they control the majority of lawyers, at least in the areas controlled by the network, right? So, but it occurred to me, right, that a good vaccine against this is, I mean, it's not a definite vaccine, but it really would help. So if you look at the docket summary, right, in any court, it lists the documents by index, right, basically by time in which they appear in the docket, and they have the title, and you have to click on the document and read it to understand it, right? And this poses an immense barrier of entry for any common person, right? But a good vaccine against this thing that they do would be to make these dockets adopt some sort of a standardized format that includes high-level statistics. Let me give you an example of what I mean. Imagine, right, that we build some sort of automated system that parses something like the legal vaccine, like the first stage of the legal vaccine that I have, right? That parses a document, does sentiment analysis, entity recognition, and understands, categorizes, right? Like, well, is this a plaintiff's document? Is this a respondent's document? Is this a motion? Is this a notice? Is this a response? Is this a request? What is this, right? And also, in the parsing, understands if it was processed by the judge, if it was ruled on, and if the decision was favorable or negative, right, to the person making the document, filing the document. If you do this, right, by automated means, and you produce a summary table, and you put it on the top of the docket, right, at the top, saying, each party, imagine that it has two columns, right, plaintiff and respondent, and it says for each type of motion, or how many were filed, how many were processed, how many were ruled on, how many were favorable, and how many were disfavorable, right? If you build this table, for example, in this case, in the family court, you will see that the only people that get motions ruled on is Morgan Hybner and the law firm, the Adams law firm, right? Like the score would be 100% ruled on in favor of Morgan Hybner, 0% ruled on the respondent, and in favor 0%, right? So just looking at the table, you can see that this is a sham process, right? You can see the bias visually without having to parse and understand this sea of legal documents with the deceptive titles that they on top put on them, right? So this is part of the system design, right? To make this process inaccessible to everybody, right? But I think part of the solution is statistics, right? Because the statistics can be fooled. If the judge is ruling only on their motions and not on the other party's motion, you can see that there's bias. If the judge is ruling favorably in all their motions, but in none of the other parties' motions, you can see that the process is biased, right? So I guess accountability requires transparency. Transparency goes beyond just having the dockets public, right? That is not transparency, because it's not transparency if the information is public, but it's not accessible, right? What good does it make the information to be public if people cannot read it and understand it, right? If you have to have a law degree to understand what the document says, right? Or what the aggregate of documents say in aggregate, right? That is the weapon. these systems need to evolve into something that is understandable by everybody, because we're all users of this system, right? It's a system that is kept hostage by a group of professionals. This is what that's what this is, right? But anyhow, I digress. So yes, what I was. Yes, so she filed that document, right, implying that there's an agreement, and asking the judge to sign something in a period of time where his hands are tied. He cannot sign anything because there is an automatic stay because of Rule 18A, right, of the civil procedure. So I mean, first of all, it's obvious that the thing of changing the title of the document is a TTP. It's a tactic, right? It's a standardized tactics that they use everywhere to get rulings in favor without having to talk about the substance, because the substance, they can't defend the substance, right? They are committing crimes. That's one thing that is obvious, right? That this thing that happened on the 10th is not, it wasn't a clerical mistake, right? This is a repeatable process, right, that they have to commit fraud at a scale. Also, the choice of the 10th of October is very telling, right? Think about it for a second. They could have created, I mean, October 10, right? They created that deceptive document saying in the title, notice of entry dash temporary orders. And it was really a notice of hearing. And that document being filed caused the Appellate Court to dismiss my petition and the motion for a TRO to protect the child. The reason there wasn't really to suppress my, as I said before, wasn't to suppress my civil rights. That was just a consequence, a byproduct of what they were doing. The real intention was so the judges didn't have to read the transcript that was in pages 102 to 140 of the petition for mandamus, the amended petition for mandamus. And I posted this on, I put the link on this video as well. In that transcript, which is of a video that I posted on the YouTube channel on June 9th, 2025, well, I recorded on June 9th, but posted it on June 10th, in which all these individuals are mentioned, right? So, I mean, that was the real goal, right? To prevent that a judge read that transcript, because if a judge read that transcript, he would be obligated to make a referral to the FBI, which was my goal, right? That's my end goal, right? Because they have me surrounded here. I can't go to the FBI to talk to somebody. I know that, right? Because they've done this before, right? With Agent Enrique Morales, right? They made me talk to him and he was compromised, right? So my goal, and I've said this before, my goal is to get a referral, right? And they wanted to kill the referral. So the fraud upon the two courts really was to obstruct justice and to block the FBI from getting the information, right? So the crime is really against the FBI, not against me, right? I'm just, I mean, my civil rights were violated in the process, right? But the real crime, I think, is against the courts and the FBI, right? So, but I was saying, right, the choice of the day when they filed that deceptive title document is important, because think about it. They could have filed the document on Monday. So October 10th was a Friday in which we had a hearing to supposedly the judge was going to sign the orders, right? That was the goal of that hearing. But the judge could not sign them because I objected to the draft, because the draft contained material fabrications, right? So remember, October 10th was a Friday, and we had that hearing that was supposedly intended so the judge would sign the orders. But then they filed that deceptive document on the 10th, right? And I had filed 4 days before my first amended petition to the Appellate Court, in which this transcript that I'm describing is included. This was on the 6th. So the timeline is in the 6th, on the 6th, which was, I think, a Tuesday, Wednesday, Thursday, yeah, or Tuesday. I filed the document that contains the transcript. On Friday, we had the hearing scheduled, so the judge would sign the orders. I contest the orders. The judge says in the hearing, let's meet in person, another hearing on the 16th, right? And Morgan Hybner, minutes later, less than 45 minutes later, files the deceptive document. right? That choice of timing is important because think about it. They could have filed the document on Monday, 11, 12, 13, on Monday 13, right? They would have achieved the same objective, right? And it would look less suspicious, right? I mean, less damning that they filed this document minutes after the hearing, knowing that the judge could not sign the orders because he set another hearing for 6 days out. The reason, I believe, and this is a hypothesis, but there must be a reason why they had to file the document on the 10th. I think it was to make it look in the future, right? Imagine, right? The time passes, the orders, the temporary orders expire, and then they swap the document, right? And it would look, I mean, whatever document was signed on the 16th, regardless, right? Even if I won the argument that the judge signed my version of the document that had only 2 pages versus the 36 pages of fabrications that Morgan Hybner was presenting, right? My hypothesis is that the plan was that even if I succeeded on the 16th, that their orders didn't get signed, they would swap them, right? They would swap them by Morgan Hybner's version, and it would look like they were signed on the 10th. Right? That's the reason why the date of that fraudulent notice is important. Because it would coincide with the hearing that was scheduled where the judge would really sign the order, right? It would make sense. Like if somebody reads the docket, if there's an audit, right? Somebody reads the docket and they will say, oh yes, these were the orders that Morgan Hybner filed on the 9th, the day before, and the judge did sign them on the 10th. But that was not what happened. The judge did not sign them, right? But if they altered the record somehow, right, Morgan Hybner, I'm talking about Morgan Hybner, right? If she altered the history in a way, it would pass an audit, right? Because she indeed sent the draft on the 9th, and we indeed had a hearing to sign the orders on the 10th, and her fraudulent notice to sign the orders was filed on the 10th. I imagine she has a way to swap the notice on itself, right? Because she cannot leave that notice there hanging forever, right? Think about it. If there's an audit in the future, or if I discover this in 2 months and come back and say, look, you committed fraud, right? She cannot leave the fraudulent document filed forever, right? That's obvious, right? So she must have a way to swap it by something that said that the orders were signed, right? That matches the title that she put, right? So that I think the TTP is fake the title first and eventually swap the document so it matches the title, right? Because they're not going to leave that evidence there hanging forever. I think that's logic, right? They're not going to leave such an incriminating evidence living in the docket live forever. I think that's just pure logic, right? So Morgan Hybner must have a way to swap it, to make it match the title, right? In the future, right? But of course, it didn't get to that point because I discovered the thing on the 16th when I went to court and asked for a copy of the document. And I saw at that point they hadn't swapped it yet, right? Because they didn't know what was going to happen on the 16th. They couldn't swap it. But because I asked for the copy that day, I see that it's not really a notice of entry. It's a notice of hearing, right? And she changed the title, committing fraud. So I think, that's the full TTP. Eventually, she needs to change the document to match the fraudulent title because they cannot leave that hanging there forever, right? Because it would be liability and would be risky, and I could discover, particularly me, right, that I'm digging into what they're doing. I would eventually discover that this wasn't a notice of entry, that this was a notice of hearing, right? So she must have a way, right? I don't know what is the mechanism, but she must have a way to make this, to correct this discrepancy, right, in the future, because otherwise it would point back at her, right? And she would have to be crazy to leave that in the record forever, right? So I don't know. I'm gonna think a little bit more about that to see how that could be done, right? There must be a way. I probably have to research a little bit. But anyhow, I think I'm gonna close this session for now, and I'll see you on the next one.